Hello YouTube, I'm Vince White. I'm an employment attorney, and on this channel, we answer publicly posted questions from YouTube users, getting folks the answers they need from an employment attorney. We have a question here from YouTube user Tiffany, and Tiffany asks us, when an employer terminated at will employment after being served by plaintiff counsel a month prior, is that retaliation, and what strategy overcomes the at-will employment contract bluff? They had already been served a month prior to termination. Okay, so first and foremost, for our purposes here today, this channel deals primarily with workplace discrimination, workplace sexual harassment claims. So I'm going to presume that you are dealing with an attorney who's bringing a case for you, either dealing with workplace discrimination or workplace sexual harassment. So when you say that the employer was served, means that I'm assuming, your attorney filed either a workplace discrimination or workplace sexual harassment case for you. It was filed in court, and then your employer was made aware of it when they were served. Great. That puts into place a presumption that any negative workplace consequence you suffer is retaliation. Now, that presumption is rebuttable. So we all kind of assume, that's what the presumption means, right? That if you experience a negative workplace consequence after you complain of workplace sexual harassment or workplace discrimination, that is retaliation, right? So here, you were terminated after your employer is made aware of your complaint. The presumption is that that is retaliation. I mentioned it's rebuttable. If you did something that gives the employer a really good excuse to terminate you, then you might not be as successful or successful at all in arguing retaliation, right? I'll give you an example. Start a case for somebody. It's a workplace sexual harassment case. And the plaintiff's attorney files the case, serves the employer responds, so you know that they're aware. And then the plaintiff, the employee, who's the plaintiff, goes in and just punches out the supervisor. Obviously, the employer terminates. Is that retaliation? Well, you can try to argue it's retaliatory, but frankly, that argument's going to go nowhere. Like, it's very few judges, juries, arbitrators are going to look at that situation, that dynamic, that series of events and say, oh yeah, this is probably retaliation, right? To compare that to a situation like I suspect, Tiffany, you might be experiencing. You've filed your case. The employer's responding. You know the employer's on notice. And then you're just going about your business. You've been working for a month. Everything's nice, copacetic. It's going smooth. It's stressful because you're suing the employer, but you're still there and you're doing the job and you're being a good subordinate. You're not being insubordinate. And then one day the employer just comes in and fires you for some silly made-up reason, which we would call a pretext, which is essentially a fake reason to fire someone, right? That, compared to our first hypothetical, that is almost certainly retaliation, right? That would be very clear-cut retaliation. Everything else is going to live between that spectrum, right? There's going to be weird cases where, like, you start your claim. You begin running your claim, the employer's aware, but you also maybe do some things that are, not so bad, but would normally be potentially terminable. And then there's an argument, well, is it a legitimate termination? Is it retaliation? And that's a fight. That's a gray area where we're going to find out what the judge or the jury or the arbitrator thinks. Now, you mentioned here the idea of at-will employment, and you asked specifically, what strategy overcomes the at-will employment contract bluff? At-will employment means the following. You can be fired for any non-discriminatory reason or no reason at all. And sexual harassment is a protected class, right? If you've been the victim of sexual harassment, that's a protected class, so that falls under discrimination. So too is having complained of workplace discrimination or workplace sexual harassment a protected class. So here, you are protected. You've engaged in protected activity. You've made the complaint. And so you can be fired for any non-discriminatory reason or no reason at all, but here the reason is actually discriminatory. It's retaliation, right? Which in this context, and I know that the way we're speaking about this is not, it's confusing because it's saying retaliation, it's saying that engaging in protected activity is a protected class, and so since you're being targeted on your membership in a protected class as someone who complained, that is discrimination. It's a bit circular, but this is how the law is to some extent written. At-will employment is less meaningful in the context of a retaliation claim because there's that burden shifting, right? The employer is viewed, easiest way to think of it, as guilty until proven innocent of retaliation. They can go into court and prove their innocence. They certainly can, right? But the best way to think of it is, on day one of that trial, the judge is of the opinion, or at least should be under the law, that they should be viewed as someone who probably retaliated. They can prove their innocence. They can come out and make an argument, and everyone can find it amazingly compelling, and that can be the end of things. It happens, certainly. I'm just saying it's a difficult bar. It's a difficult evidentiary hurdle for them to jump over because they come in down. They come in with an assumption of guilt on that specific retaliation claim. None of the other claims, just the retaliation. And that's really important to your situation here, right? You don't have to worry about at-will employment. I know what you mean by the contract bluff. Generally, at-will employment does have a contract. It could. At-will employment certainly could have a contract and sometimes does, but generally speaking, at-will employees are not subject to a contract. Now, I also don't fully understand what you mean by the bluff, right? I assume when you're speaking with your attorney may have said something like, hey, the employer says, I contacted employer's counsel. Employer's counsel says, well, you're an at-will employee, so they went ahead and fired you. Calling that a bluff is the correct thing to do because that is not a very sound legal footing, to be honest with you. That is going to be challenging for them to argue. It puts them in a difficult position, and if I was a defense attorney and I saw that my client did that, I would just think they were so stupid, right? The conversation with that defense attorney probably went a little something like this. Hey, yeah, you need to call me before you do things like that. That was a real bad idea. Part of my job is to triage cases, make sure it doesn't get any worse, right? Stabilize the case, make sure the case doesn't become more valuable, a bigger liability for you as an employer. And it's tough for me to do that if you're going to go ahead and just do dumb shit like what you just did when you fired that person, when you fired Tiffany, right? That's the conversation that's probably happening if you have an experienced defense counsel on the other side and the client, the employer that fired you here, right? That's probably the vibe. So I assume your attorney is an experienced employment attorney and is telling you, hey, this is great. Sucks that you got fired. Terrible for your quality of life. Terrible for you in the short term. So difficult. In terms of the valuation of your claims, good news. Really good news, right? Like it's party time. Let's go. So, it's not all bad news is what I'm saying here. You're in, believe it or not, a somewhat enviable position. That sounds like a stupid thing to say. But your case has gained significant potential value and strength thanks to that termination. Potentially. That's what it sounds like. I don't know the context. I don't know exactly what went on, but there's a good chance that your case has gained value. And that's great. Listen, I hope that your attorney takes them to the cleaners for you. I hope you get paid big. Comment down below if there's clarifications where I didn't know some facts from your question. You want to add some additional information. I'll make you a follow-up. But other than that, like, subscribe, comment down below. Share the channel so it may grow. I hope everyone is well. Take care.